Okay, we were on our last video for Chapter 2, the resolution of private disputes. Yay! Okay, and so we've talked about jurisdiction, and we have a handout for trial versus appellate courts. We're going to talk a little bit about civil procedure as far as how we go about getting into court and what happens from there. And then alternative dispute resolutions are ways of settling a case without going to trial. So when we file a lawsuit, the plaintiff, they must file what we call a complaint or a petition. Okay, and that sets out the basic allegations of each element. Remember, we talked about elements. You need to make sure you put in there. It can be brief and concise, but you have to hit every element that you have. And then what you do is you have a summons, which is a notice of lawsuit, and you have all of that served to the defendant. What the summons basically says is it's issued from the court and it says you've been sued. And sometimes the court will schedule a hearing right away and that'll be on the summons. The defendant will get that and that defendant will need to answer. And depending on the state law, they have a certain amount of time to answer. Federal law is all the same. That same time, they can do what we call a counterclaim. Hey, I want to sue you. You sue me. No, I sue you. So they can do a counterclaim. They also have to lay out any what we call affirmative defenses. And you don't need to know all of what they are, but if, hey, I'm going to say that you can't meet your claim, I need to put that in there, failure to state a claim. Or I need to say, wait a second, this is past the statute of limitations. So I put that in there. I serve that back to the plaintiff, and the plaintiff then has to reply, and they have a certain amount of time to reply. So those are what we call the pleadings, okay? They're the initial documents that are filed, the complaint, which is the petition, the answer, and the reply. It puts the parties on notice. So we have the complaint that has a summons, then the answer and reply, okay? Then you can do your motions to dismiss, and those are going to be things like I didn't get proper service, or the court doesn't have jurisdiction, or we're past the statute of limitations, those legal basic motions to dismiss. Okay, those are usually before discovery. What is discovery? Discovery is exactly what you think it is. I'm going to discover everything I can. And it's pretty actually lenient as far as what you can ask for. There's different kinds. First, you can ask for interrogatories, which say, hey, I'm going to ask you questions and you need to answer those questions. And I also can do a request for admissions that say, I admit blah, blah, blah. I admit blah, blah, blah. And if the other party wants to deny it, they need to respond that they deny it. You can ask for documents. That's a request for documents. And then you can do depositions. And depositions are expensive, but they can be very, very worth it. Because you can get a lot of good information out of that to help your lawsuit, and you can lock your witness into testimony. So your witness is under oath during a deposition. Their attorney is there. They have one. And you have a court reporter. So if they say something during the deposition that's contrary to what they say at trial, you can say, Mr. Jones, in your fancy lawyer voice, Mr. Jones, you just testified that you did not hear anything the evening of such and such. Mr. Jones will say yes. Now, Mr. Jones, previously you took a deposition, is that correct? Yes. And I was there. Yes. And your defendant or your attorney was there. Yes. And you swore under oath, right? You took a oath, right? Yeah, to tell the truth and the whole truth and nothing but the truth. Yes. Just like you took an oath in front of this jury. Yes. But during your deposition testimony, you said blah, blah, blah. That contradicts, and it's great impeachment. So depositions can be very useful, but they can also be pretty time consuming and costly. Now, there's many motions you can file. You can do a default judgment, which means they never showed up or answered to your original complaint. You can do a motion to dismiss. A motion to dismiss could be because of they didn't have proper jurisdiction, or that it was outside the statute of limitation. A motion for judgment on the pleadings is similar to motion for summary judgment, which again, we talked about this, plus we have a video on it, and that is, hey, you can't make your case. Or we can do a motion after the plaintiff has presented their case saying you did not do what you needed. But that is during the trial process. The summary judgment would be before. Then we have a pretrial conference prior to going to trial. This litigation timeline is on this page, so you will have it if you would like it. So what happens during the trial? Well, after we have jury selection, the plaintiff gives an opening, the defendant gives an opening. Why does the plaintiff go first? Because they're the ones that brought the suit, brought the charges, and they have to present their what they believe the evidence will show. And that's why the plaintiff goes first. They present evidence, they have witnesses, the plaintiff will direct, the defendant will cross. Sometimes the plaintiff will redirect or the defendant will recross depending on the court. Objections are made. And as soon as they present all their evidence and everything, the defendant then can put their evidence on. Okay, and in a civil case, the defendant wants to put evidence on because although the burden's on the plaintiff, they can draw inferences if the defendant doesn't refute it. Okay, then you have jury instructions, which will tell them, hey, jurors, this is what the law is, and you need to see if the defendant or the plaintiff proved every element to that law. The plaintiff will give their closing, the defendant give a closing, and the plaintiff will get a chance to once again get up. They get the last word. So that is how the trial works. This is also attached in this page for you to have as well. During the whole process prior to trial, there should be negotiations. There should be an attempt to settle. Why? Because litigation is a pitfall. It costs money, it costs time, and it costs effort. So most cases actually do settle out of trial, and that's what they try to do. And negotiations are just basically talking back and forth, trying to come up to a settlement. But we have two, and this is all considered alternative dispute resolution. An alternative, right, for our dispute to resolve it. There are two formal alternative dispute resolutions. We have arbitration, mediation, two different things in how they work. Arbitration, you have an arbitrator, they listen to the facts and evidence, they render an award. They say this is the award, and it becomes binding on the parties. Now, a lot of times a contract will say we agree to arbitrate, and that's because companies don't want to litigate. They don't want to run the risk of being looked like the big bad company and possibly losing. So they want to go to arbitration. So quite often, if you see an arbitration clause in any contract you sign, what it's saying is, hey, we're not going to go to court. We're going to arbitrate. And they are binding, and you have to do it. Mediation now is something separate. Mediation is we're not going to arbitration because we don't have to. Most people just don't agree to go to arbitration because if you're going to go through all that expense and stuff to put it before someone, a lot of people like to argue to a jury. But mediation is where a mediator listens to the parties and they kind of help, the mediator will help define the issues and understand it and say, okay, let me just tell you where you are. This looks like you probably are going to lose if you go to trial. But perhaps we can settle here. Or in my experience, juries don't like big companies. So here's the deal. The mediator will try to get the parties to settle and they form an opinion, but it's not binding. Mediation is just having a third party there to help with negotiations. And again, these are both alternative dispute resolutions. They work in a lot of cases, and a lot of cases are settled prior to actually going to trial. This will wrap up the lectures for this chapter. So if you have any questions, contact me and I'll see you next chapter.